light though. Oh, there it goes. Okay. Good evening, and thank you for attending. This is the Wednesday, September the 10th, 2025 meeting of the Tenant Landlord Commission. My name is Andrew Ferrer, and I'm the chair. I would like to acknowledge we do have a forum. If someone could silence their audio, we are getting some feedback at the moment. Thank you. I would like to acknowledge that we have Sarah Lanford, Kristen Clegg, Adrian Tamala, and Griffin Copel present. And of course, we have one of our county board liaison, Maureen Coffey, present as well. We'll move on to the first item of business, which is public comment. Right now, we have two registered. So first up is Young Choi. Are you on the line?
Yes, hello.
Yes. You have 3 minutes to address the commission, and we'll wait for Hector to start the timer, and then you can begin.
Sure thing.
Okay, floor is yours.
Thank you. Hi, so my name is Young Choi. I'm a resident at Arlington House Apartments, and for the last 2.5 months, we've been having a neighbor of ours smoke marijuana, and it's been coming directly into our bedroom, into our living room, and it's been happening multiple times a day, almost every day, multiple times a day, and oftentimes at like 2, 3, 4, 5 a.m. So it often wakes us up. The issue that we've been having is primarily because we have an infant, newborn, 1 month old, and we've tried to speak to the landlord to see if they can terminate or break the lease so we can get out early, citing that this is uninhabitable for us. We've gotten multiple letters from our pediatrician saying the smoke intrusion is definitely a health hazard for the baby, and citing that, we were saying, can you please let us out? For the last 2.5 months, up until last week, the landlord has taken no action other than to say, we're investigating, but here are the options, which is basically leave by paying a penalty or move to a new unit with by signing a full new lease, or basically try to find the subletter and everything, all the options that they're giving us, all just basically on me to take on all the financial risk. So multiple back and forths. I've tried to speak to them, just trying to appeal to the humanity of the situation where, we really need to get out of the apartment, but we can't pay for 2 leases at the same time. And they've gone back and forth from, I guess, their attorney, and they concluded that this is not a health hazard in their interpretation of the law. And that's the gist of the situation. I'm trying to see if there's anything else. Well, am I leaving anything out? Yeah, oh, so yeah, that's right. My lease ends on November the 14th, and I was just asking for about 2 months early release. So I'm just in a situation I'm in a bind. The landlord has refused to budge. They have not entered the premises until last week when we gave them a notice that the smoke was coming up, and it was thankfully just during the work hours. They came, they looked around, smelled a little bit, and I think they've tried to identify who the smoker was, and maybe they gave them a little bit of notice, but it still has been happening multiple times a day. And yeah, I'm just trying to get out the lease early, haven't been able to move the landlord anywhere, budging towards that kind of decision. So I asked them to come here to try to mediate a little bit too. I don't think they are here, so I'm coming to you guys for advice or whatever else information you guys can provide for my situation.
Thank you so much for your comments. I will now open the floor to commissioners. Yes, Kristen.
I have a question for you, Mr. Choi. Is your building a smoke-free community?
It is smoke-free. They say that in the lease, they do not guarantee that it is a smoke-free facility. One point in that same paragraph says that the landlord is not, I'm going to quote, they're not obligated to act and investigate until I give them notice. So I just took that part to say they have some sort of obligation to look into the issue. And I would say, again, they haven't taken any action until last week, which I think they took the action of notifying whoever the tenant was, whoever they think it was, to possibly stop smoking. But again, to repeat, it's still happening.
Mr. Troy, have you have documentation of when you started this communication with your landlord?
Yes, the first email I sent to them was August the 6th, and I had tracked all of the instances of the smoke intrusions, and I would say we have accounted for over 40 instances, and we sent them all to the landlord every time it happens.
Thank you. Sarah.
Hi, thanks so much for being here tonight. I imagine it's very, very frustrating, especially with a newborn. So thanks for taking time out of your night to come speak with us.
I appreciate it.
I'm curious if you've spoken with other tenants in the building. Do you know if anyone else has experienced something similar?
I have not spoken to any of the other tenants. I did consider sitting outside in the front of the lobby area and, holding up a sign, hey, anyone else have a key? And try to collect, petitions. I wasn't sure, what actions I could
No,
take.
I asked because I've also done that kind of same tactic when there have been smokers in my building. I was just curious if other folks had noticed a similar problem.
Yeah, I'm sure they do because the landlord does send out almost a monthly email to the residents saying, hey, please don't smoke 50 feet within the boundaries of the building. But that's one of the actions that they would say that they have taken, which is, oh, we've been sending out these notices and emails.
Yes, Adrian.
Hey, how you doing? Quick question. If you don't mind me asking, what is your deposit amount and what is your rent amount?
Yes. I think the deposit, don't quote me on the deposit. I think it's about $800. The monthly rent, utilities, and all the other fees included, it's about $2,300 a month. So the first email communication we sent, we tracked about 15 different instances, and we asked them to get out of our lease, release us from our lease by September 14th, which would have been a 2-month early release. But again, that's been denied.
Have you spoken to the general manager or the regional manager of I'm sure it's a property management company that's operating the facility?
Right. It is managed by Bell Partners. We have asked frequently for who to elevate this instances issue to. We've also asked for maybe an on-site personnel, maybe who would be here accessible 24/7, so that when all these instances happen at 4 or 5 a.m., we can tell them to. So to answer your question, no, I haven't been given that name. We did find someone on Facebook that might be the regional manager, but that information is not verified.
Okay, thank you. Kristen.
So, Mr. Troy, I'm a landlord, and unfortunately, with 5,000 units in the Arlington area, we get the same complaints that you register. And as a non-smoker and someone who hates all that, I completely agree with you. I mean, I couldn't tolerate it either. However, I do want to present something from the landlord side, just so you know. Number one is a landlord can't discuss with you the actions that they're taking against another resident. It violates their privacy. And number one. Number two is a landlord, in order for them to enact any part of the lease, such as the no smoking policy, we're required to verify it. And the biggest challenge that we have as landlords, as you've already indicated, is who's the smoker, who's doing it, and getting someone to answer the door when you knock on it and say you're smoking. And it is a horrible quandary for a landlord, because we all put in these non-smoking units. When we turn that person's apartment over for a new person, it's going to cost tens of thousands of dollars to remediate that smoke. So we don't want to do that. But then the other thing I wanted to say is the Virginia landlord tenant law has rules that we have to follow when we are going to enforce the lease. And you may not be aware that the landlord is already taking those actions, and the actions can take up to 30 days from the date that we have notified the offender. And so, again, I don't know that your landlord's doing any of that. I sure as heck hope they are. but I wanted you at least to understand what could be happening behind the scenes. Not saying
Yes.
it is, but I can understand why a landlord would not tell you those things because they can't.
Understand.
Sarah?
Great, thanks for providing that context. I know when I was in a similar situation, they were telling me we're trying to work on it, but we can't say anything else. But I think it's important to note that that can be true. And also we could encourage them to let them get out of the lease, right? Like those two things are separate.
Right.
And so it seems like the issue is not, is this person going to get evicted or punished, but like, can Mr. Choi and his family break the lease? So I would encourage us to pressure the owners to let these folks out of the lease early. I don't know if that's authority that we have, but
Well, you can certainly have the county reach out on our behalf to inquire further on this regard and see what appropriate actions they can take that are within their power to do so. So Kara, I think Mr. Choi, thank you for your comments. If it's okay, we'll have Kara, our staff liaison, reach out on our behalf and inquire further into this and see if we can find a reasonable solution to all parties.
Yes, I would appreciate that. Thanks so much.
Yes, and thank you again for bringing it to our attention. Okay, next that's registered to speak is Mr. Nikhil Desai.
Here.
Yes, you have 3 minutes once Hector puts up the timer.
Okay.
Okay, you can begin to address the commission.
My name is Nikhil Desai. I have been living at Culpeper Garden on North Pershing Drive in Arlington since early 22. And the immediate problem is that I was surprised, shocked, 6th of August or 7th of August when the director of property operations here sent me a notice of lease violation, charged me with reckless driving and hit and run as I was getting out of my parking spot in the parking lot, and he revoked my parking pass. I cannot park in the parking lot, and if I park on the streets, I am unable to get to my apartment. If I cannot do that, I cannot go out to see anybody, including doctors and gym and physical therapists. I inquired the next day if any police report was filed, and the answer was no. I inquired with DMV about my driving record. It's in perfect condition. I immediately sent, or before that, I actually denied these allegations and also stated that this is continuation of a pattern of harassment about parking and about other policies which I did not expect from Culpeper Garden. And nothing has come of it. I have no opportunity to defend myself or, find an alternative solution for parking. I have finally applied for accessible parking, but that has been in quite a few days. Should not have been necessary in the first place because I already had a handicap sticker from DMV for more than 10 years, and it was part of an implicit agreement with the lease that my parking would be considered with it. That's all I will say for now.
Thank you so much. I will now open the floor to commissioners for questions. Yes, Kristen.
So, sir, do you have a lease agreement for your parking permit that outlines what the speed limit is and the way you're supposed to park and the way you enter and exit the building, parking areas and so forth?
Not in the lease. The lease is entirely silent on parking or driving in the parking lot. The parking lot itself has several speed bumps, and it is just difficult, if not unimaginable, that anybody can go at a very high speed. Hit and run, he himself said nobody was injured. And he charged that I did not stop to inquire. On the other hand, I had no reason to inquire. He did send a picture of a broken wooden railing at the patio, which I had seen for at least 3 days before that. Somebody else told me the next day that he also had seen it for 3 days prior to that. So I have seen this as, just a, how shall I say, persistent harassment. I have asked many questions, asked for help in finding a solution, and it's been going on for about a month, and he has stonewalled everything.
Yes, Griffin.
Yeah. First, again, thank you for your time. You mentioned this kind of item of a pattern of harassment. Have there been other issues that have come up between you and your property manager that have kind of led to this being another example of a pattern of harassment?
Thank you for saying this. There are, in particular, it started in December 2024, when, because of the way they record rent payments at the same time with all the other charges, that I had fallen short, because they also delayed cashing an automatic check that I was sending from my credit union. After which, according to their policies, which are not part of the lease or other agreements, he said I was in violation of the payment policy and I would not be allowed to submit any rent checks or cash. So I tried to get my son-in-law to submit his check, and he denied that too, which meant I had to go to post office and stand in line. It was a rainy day and I have difficulty standing, but somehow I managed $95. It wasn't even full amount of the rent. It was just, different accounting systems. After that, it was around April that the dispute started precisely on parking. Since I came here, about 23 spots have been reserved for staff and visitors. And until April, the front desk people, the understanding was, if a resident, especially somebody like me, did not find a spot in the parking lot, then could leave my car overnight or even longer in the visitor spot. And once I put it in the staff spot, because it was weekend and Monday morning it was heavily raining, I couldn't get out given my physical condition. He said I should remove it, otherwise it will be towed. Fine enough. Then a few days later, it was in the visitor spot. And I did then, dispute with him. And I said, you are prioritizing visitors over disabled residents, and this is harassment. And he dismissed, the argument. Then it happened again in late June, early July, when resurfacing was going on, and half of the parking lot was not available to residents at a time. And I asked him, I said, what this means is that for disabled people, instead of the 8 handicapped parking spots you have, there'll be only 2 or there'll be only 6, depending on which part of the parking lot it is. And could you arrange for somebody like me to have a parking in the part of the parking lot which is not, being resurfaced? And he said no. And then suddenly this happened on August 6th. I had been, because I could not park many days in July, I was not able to go out very much. My doctors or physical therapists or pool or gyms, and I was getting somewhat more disabled. But at the end of July, I started going to the gym, started going to the pool, and suddenly I was hit by this false notice, and I have asked, what part of the lease have I violated? No answer. If you have reported me to the police, where is the record? No answer. And he has not even replied to my auto insurance company in more than a month, saying just exactly what he is asking as damage.
Oh, are there any other questions, Adrian?
Yeah. Hey, how you doing? I'm Adrian. I'm also from the landlord side. I'm a regional property manager here in Arlington. I have a question for you before I can give you a few opinions with what you're going through. It's parking. Do you pay for parking at your property? Is that included on the rent? Is it a line item on your lease, or it's free parking as given for the residents that live there?
No, it's not included as a line item in the rent.
Okay.
The lease itself says nothing about it.
Okay.
There is a document of parking policies, which were revised in April. And as I said, before April, I didn't have a problem parking. It was in April when I could not even park at the last resort in visitor spots or anything. That's when everything just became worse. You had another question. I'm sorry, I didn't respond to that.
So that was my question. So I do want to give you my opinion from our point of view. I mean, at least I can speak for myself and the properties that I manage and I supervise. Is this Arlington County? A lot of the properties that were built in the 60s, 70s had X amount of parking lots. Nobody thought had more people were going. Nobody really thought about like, oh, 20, 30 years from now, a family of 4 with 1 car, their kids might grow up, might have 3 cars, right? So I am full aware of parking situations with a lot of properties in Arlington. That's why a lot of the parking spaces are first come, they're free. You're not paying for parking, but it's still first come, first serve. The one thing that I can tell you is that if in the property that you're in, and you do have like you said you do see handicap spots. I think this is one of the first comments that you said your parking spots. I've experienced that too, and we try our best to whenever we receive an accommodation, if with the possibility to put a new handicap spot on our property, we always tell our tenants that we are doing this as for your accommodation, but keep in mind that anyone with a handicap tag can park there, right? So I understand maybe where the property manager was saying those things. Maybe the feedback for them will be maybe like explaining that why there's certain things that he or she has to say no to, at least on that aspect. And correct me if I'm wrong, Kristen. When it comes down to property damage through insurance, the property manager, I mean, if he doesn't hold any of the liabilities or deals with insurance, that will be just handed to the next person. The manager wouldn't handle it.
Well, this is a very unusual situation because I don't see how the property manager knows that he's done it. I think Mr. Desai involving his insurance company and having them reach out to the property was going to be my sort of secondary question to him is, I know you've spoken to your insurance company, but have they directly contacted Culpeper Gardens? Do you know?
Let me answer that question first, and then I'll make a comment on the previous one. Yes, I contacted my insurance company on the night of the 7th August. Then I have been in touch with them until a couple of days ago. They told me that they left him a voicemail on the 8th of August immediately, and they had not heard from him for 2 weeks. That's when I inquired again with the property manager, and he said, oh, I never received any voicemail, but I got 3 emails from Geico, which had gone to spam. I said, okay, fair enough. Then I called Geico again. They said he did contact them, and this was about 10 days ago, but he said there was no estimate ready. It will take time. In the meantime, that wooden strip or post that was broken has been repaired 3 times already. How he did it or whatever, but I don't buy the argument that he doesn't have an estimate. It all looks like he's just going to continue stalling on any part. And the previous, now if I may, can I respond to the other earlier question?
Yes, but please be concise. We do have other items in the agenda.
Okay. In short, this was built in the 1990s, and I came here with my placard, and the issue here is not whether I get an assigned handicap spot. That's a separate thing, and I have finally made the application. A disability certificate has been sent and should not have needed. The question is false criminal allegations. Can somebody just go and say, oh, so-and-so did a hit and run, nobody was hurt, but he is still a criminal, without even reporting it to the police? And then saying notice of lease violation without any basis, without any follow-up, and saying, this is what you violated, this is what you need to do. This is an absolutely arbitrary, unconscionable harassment, in my view. And I have been told to go to the Office of Human Rights, which I'm like, so I don't know.
Yes. Thank you, sir, for your comments. That is actually an excellent recommendation to forward your concern on to the Office of Human Rights for investigation, since what you raised may rise to the level of allegations in violation of discrimination ordinance in Arlington County. But again, we're not lawyers, so we can't give, that's not legal advice, but that's just a recommendation, and they will be able to rule on the validity of your claim. But we'll definitely also inquire for landlord about your other comments, but please do follow up with the Office of Human Rights. Thank you so much. Is there anyone else on for public comment? Hearing none, the first item then is the approval of the minutes from July. And are there any edits? If not, is there a motion?
I move to approve the minutes from July.
Motion has been moved and seconded. All those in favor?
Aye.
All those opposed? The ayes have it. The minutes are approved. Okay, moving on. I believe our first speaker is Jennifer Daniels regarding the report from our April recommendation. Jennifer, thank you for joining us.
Hi, good morning, good afternoon. I'm in Arizona, so I'm a little bit discombobulated, I have to say. Okay. I'm sorry, let me retry this.
No worries.
Are you seeing a black screen?
It's queuing, and then now it says your PowerPoint is not responding.
Yes, okay.
Now
it turned it off.
If you want me to do the slides, you can just talk.
Can you do the slides, Hector?
Yes.
That'd be fabulous, thank you. I will stop sharing. I was gonna stall while I was trying to reload.
Sorry.
Great, thank you. Can you run it as a presentation? Perfect, thank you. Okay, we know this is a relocation guidelines update. Next slide, please.
It's at the bottom.
Okay, I see it now.
Thank you. So the context for this is, as you all know well, the Arlington County relocation guidelines were established way back in the 1970s to set standards and provide administrative guidance for owners assisting tenants facing displacement from residential rental properties. I'm sure you all know this. For any projects that have federal money, they have to follow the Uniform Relocation Act. Arlington County sort of went one step further and developed its own for any properties that that are being redeveloped or refinanced or sold or whatever that need to go to the county board for approval. So the guidelines were last updated in 2018. And you all created a subcommittee earlier this year to examine current guidelines. So that included reviewing guidelines from neighboring jurisdictions, talking to county staff and partners about what was working and what wasn't working. And you all provided a report and recommendations to county staff for consideration in spring 2025. So first, I want to say thank you so much for that. I know there was a lot of work that went into that and a lot of research and a lot of really thoughtful kind of investigation. So we very carefully looked at your recommendations, and here's our recommendations that we've developed based on yours. So I'm sort of going point by point because I'm hoping that makes more sense. If it's too weedy, let me know. So you had looked at the assessment of tenant needs and preferences, which is section 2.3 in the current relocation guidelines, and recommended any hardship the tenant may experience during relocation, and if the security deposit is required in advance of relocation, and that was a suggestion to add to the tenant profile. We did call out the hardships tenants face in section 2.3. Also in 3.1, which is really more related to the payment, so it kind of made more sense to fit there, put in cases of hardship, the return of security deposit and any accrued interest should be expedited on or before vacating the property. And under the Virginia Tenant Landlord Act, we cannot require that a security deposit is returned before the tenant vacates. So what we can do is we can request expedited return and work with the landlord to do that. So next slide, please. I'm sorry?
I said, sounds good.
Cool. All right, so the tenant profile, lots of recommendations, and I want to frame this first as it was a real balancing act because we understand that you as the Tenant Landlord Commission really want a good picture of who's in the household and really want to be able to understand the relocation guidelines. On the other side, we're really trying to be careful about privacy concerns. I mean, especially in this environment, we really don't want a lot of published data that doesn't need to be. So all that being said, let me kind of go through the pieces. So you wanted us to add the number of individuals in each household. What we did is we're adding household size and household mix. So what that will do in the tenant profile is it'll show you, there are 4 households with 3 people with this many seniors, that sort of thing, but it won't provide kind of individual identifying information. So hopefully that'll still get you the information that you need. Similarly, add school names, locations, and special requests for each school-age child in the household. So what we suggested is adding the list of the schools in the school district. Obviously, that's really important as you're doing a relocation. You need to make sure that kids, whenever possible, can stay in their school district. So again, we don't want to individually identify people, but we do want to make sure that we have the school districts and the schools as part of the relocation plan as it's developed. Add location of employment. We're suggesting adding, again, the household area of employment sort of consolidated. And not looking specifically at employer. I think, again, we were worried about that from a privacy perspective. And so I think what we thought you were getting at was really, do people need to commute? Are they close? Are they far? So I think what we are recommending is people in Arlington, people in other jurisdictions, and that'll give a better sense of kind of what the needs are as far as location and transit and things like that. Similarly, add transit or transportation needs, including on-property parking spot availability. We made that more general, and there were several reasons for that. One is that a lot of our affordable housing properties no longer really have a parking requirement. So it wouldn't necessarily be possible to do a one-to-one. If you had a parking spot in this location, we can guarantee you have a parking spot in that one. And obviously, as and this is the relocation plan, this is the general plan. As the relocation specialists that the developers work with are working individually with people, obviously, hopefully we'll be able to drill down and really meet those needs more individually. But again, keeping it fairly general, just so that there's a sense of kind of all the households, what are the needs, and that kind of helps give you all a sense of what the general needs are. So as I said, really try to, understanding you want more information, also understanding we want to protect tenant privacy. So hopefully we kind of split in the middle. So next slide, please. And I will say, I did say this story, but let me just clarify this. The tenant profile is publicly available because you all review it. So that's something that's in the public record. The relocation plan, well, that comes to you publicly also. Some of the records that are kind of behind that, that the developer keeps that are really individual level, that are really looking at the profiles, they still do all of that. It's just not publicly shared in this setting. So again, trying to balance that need. Okay, section 2.4 in the profile, you had also suggested formally adding the point value assigned based on the point system. So just to give a little context for that, the point system, and I'm sure you all know this better than I do, is really to look at individual needs if folks are being temporarily relocated. So they're being displaced from this property, they're going somewhere else for a year or whatever, and then they're going to have the opportunity to come back. So in those cases, obviously we want to prioritize people to come back. And there's a whole series of points that are given that include, tenure, have they been dislocated before, do they have special needs, income level. So there's a whole bunch of stuff. So, and your suggestion, commented that this was a good faith effort, but it wasn't really formalized. So what we're recommending is that it become more formalized in the sense that when after tenants have relocated, then they really do look at the priority list, and then Hector or the relocation specialist will really track it more formally to make sure that folks are able to get the opportunity to come back. And the reason for this sort of different thinking is that the point system at the time of relocation may or may not be that valid, because often people will move and they'll be comfortable in their new place and they won't want to move back, or they might have made other choices by the time a relocation happens. It might be 1 or 2 or 3 years later. So we don't want to lose the point system, and we actually really appreciate the idea to formalize it more. So hopefully we're doing that by really having our relocation specialists take a kind of a deeper look at that and continue to track that as people start coming back to the property, as opposed to doing it up front when, it might be a year or 2 before folks have the opportunity to move back. So next slide, please. Okay, your next is 2.6, and that is under the section of Tenant Landlord Commission review. What you all suggested is add the Tenant Landlord Commission shall not consider a relocation plan if the tenant profile is incomplete. We would like to change that to they may not, so they can choose not to if there's an incomplete profile or the relocation plan summary is not provided in a timely fashion, because we understand it can be frustrating not to have all the information that you need. But sometimes folks don't want to answer the tenant profile. So sometimes it's just not going to be complete until people are closer to moving. So we just want to make sure that it does not hold up the project. So we're hoping that this different language kind of gives it more of a case by case option. So again, if you all feel like really we don't have enough information, that's fine. But we didn't want to make it but you may not consider it if, if a few people have chosen not to fill out their profile, or they don't have it together yet, or whatever. So next slide, please. Okay, back to review. You asked that this was just some changes to language. I think you want, as you all know, at your first meeting, you have the opportunity to make recommendations based on public comments by tenant, owner, neighborhood representative. I think you all recommended adding past precedent and any other interested organizations at the meeting, so we added that. And then at a subsequent meeting, the Tenant Landlord Commission will review the proposed relocation. If concerns have been resolved, they may proceed with voting on the relocation plan if appropriate. And I don't remember what the change was from what we had previously, but we added that. So next slide, please.
If I recall, it's at the next meeting, and that was to give it some legal ambiguity, just in case it might take 2 meetings rather than the next.
Got it. Yeah. Okay. And I think that's what the previous point was trying to get at too, is if you don't feel comfortable, then this gives a little more wiggle room.
Yes.
And I think it
Okay.
said like will approve.
Yeah,
instead of
it will.
Instead of may.
Yeah.
Yeah, instead of.
That's what it was. Yeah, thank you. Okay. Next slide. So relocation services. So this is the section on what services people actually are entitled to. So what you had suggested was splitting out projects that are undergoing rehab, conversion, termination, and subsidy or other use changes, and projects undergoing demolition. And your rationale was that particularly for demolition, people aren't going to be able to come back. And again, the return of the security deposit should be expedited on or before vacating the property. So that's what we added. So our suggestion is, well, first of all, the VRLTA, as I mentioned, does not permit the use of the deposit as last month's rent. Sorry, I didn't mention that. We are not, that is not legally allowed for them for people to do that. And also, we are not allowed to require that security deposits be returned before people vacate the unit. So again, in cases of hardship, obviously, we would work really closely with the property manager and ask that security deposits be expedited to the extent possible. Next slide. Relocation payments, I think this is the most significant recommendation you all made, which is to modify the Uniform Relocation Act payment schedule to be tethered to the highest jurisdiction in the DMV. So just if you know, you don't remember how this all goes, the Uniform Relocation Act is the federal act that, again, requires relocation assistance for folks who are being displaced from federally funded properties. We use those guidelines, and there's a payment schedule based on location. So ours had previously been tethered to Virginia, which is not as high as the one to DC. So obviously that makes a lot of sense because then folks are able to get a higher payment based on, and Arlington is much more related to DC from a payment perspective, obviously, than the rest of Virginia. So we went ahead and updated both of those, both for the relocation payments and for the very low income tenants with updating the room equivalencies. So that will be indexed to the URA payment schedule. So as that changes, ours will change as well. So next slide. So other updates, we removed pronouns from references to county manager. That was one of your suggestions. We also added an appendix with applicable laws. So the Virginia Landlord Tenant Act, some of the Arlington codes, so a couple of things that really, so people can go back and check that. And then minor edits to capitalization and definitions, which I won't torture you with. Next slide, please. So yeah, I wanted to thank the TLC subcommittee. Again, I know you all put a ton of work into this and you know, it's really helping us because obviously we want to support tenants as best we can. So I think some of these changes are really going to be helpful. Next slide. Oh, I had another slide, which I guess I added in a different version, which was basically next steps. So the next steps are the way that county board action happens. I'm sure you all know this is staff writes a board report, which then goes through our whole process, our legal review and all that kind of thing. So we're working on that so that the county board will consider it at its October 11th meeting. We would love your support if you want to vote on this or write a letter or something like that, just to say that you support these changes. And then once that's adopted, any subsequent relocation plans will be under these new guidelines.
Awesome.
So that is it for me. Any questions?
Open the floor to commissioners.
This is really helpful. Thank you so much.
Yeah, this is great.
Great.
Yes. Thank you. Enjoy Arizona.
Thanks. Have a great day.
Bye, Jennifer.
Thank you.
Bye.
Okay. Next is the
Just to visit in.
Oh, okay.
Presentation center.
I was gonna say that.
This would be fun to say.
Next is our legislative priorities discussion. Thank you all for working during August and reviewing some documents and relating to us.
Anybody need a copy of it?
It's
Easier to look at.
Thank you.
So did you need a copy by any chance? So,
I'll take one.
yeah. Just to let you know, I made all of the ones in bold. Those are the ones that Housing Commission shares. Yeah. Those are the ones that- So any of the ones in bold, those are the ones that the Housing Commission also had up for their priorities as well.
And what were our ranks from?
So
Shall I go?
I narrowed down all of them. I wanted to do 5, but then it ended up being 9 because there were so many. But if I look at the ranking that I actually did, number 2 and number 3 were actually tied for first.
Yeah.
And then number 1 was the second one. And then number 8 was the third one. And then everything else came in with one vote.
Okay.
I got the.
Yeah, well, the floor is open to discussion. Maureen, is there any guidance from your since you're our legislative liaison too?
We're actively working on this. I also sit on the Virginia Municipal League Legislative Committee, so representing localities in Richmond. And we're also working on our CML legislative agenda, so I'm very deep in all of this right now. I think number 2 and 3 that you highlighted as priority 1 level, these have been in our package for quite some time, and I cannot imagine them not being a huge priority. I think, I would love for our package to be even more explicit about the specific things that we want or don't want. Obviously, like enhancing our ability to enforce is great, but I think there's going to be a lot of questions from lawmakers around like, what would a local enforcement process look like? We may not, may not have thoughts or comments on that at this point in time, but the more detail that I can get, I think some of the pushback is easier when there's clarity for legislators about like, what does it actually mean in practice?
Can I ask a quick question?
Yeah.
Do you know what the specifics were in the bill that was passed last, and like if that was sufficient to address those concerns, or maybe there's a rationale by the governor in the veto?
I know it was carried by Sia Price down in Hampton Roads area. I don't know if anyone on staff has a better memory of the specific. I will say that this was one that we definitely supported, but we didn't do any, we didn't get involved because it had so many advocates behind it. It didn't require as much. So Sia is a really good legislator, and so I trust her legislative writing ability. I just think that for bolstering like our legislative agenda package, like being able to say what we envision this looking like can be helpful. It doesn't have to be, but I think that's just, since it's been a kind of line item, enhanced tenant enforcement, it gets a little stale. Sometimes people are like, what does that mean? And we can't attach, in our legislative package, we're not going to attach previous bill numbers because all the bills can change. It may, theoretically, I doubt this, but it could even not be submitted in the same form next year. So if we can't just rely upon whatever was put there last time. And then I think, the other one that is kind of interesting that it didn't jump out for everyone is the technology for price fixing in rental housing. I think that has been a really, it's been a really hot topic.
These days, yes.
Especially these days. The DC Attorney General has been pursuing that pretty vigorously. Our Attorney General would be the only person able to even we would either have to have a civil suit coming as kind of like a class action from tenants, or our Attorney General would have to take it up. There's no cause of action for a locality who suspects that something is happening to enter the nexus here. We have seen settlements being reached in other parts of the country at this point. I think that it's something that there is some interest in, and I think the analysis shows that Arlington and Alexandria have some of the highest concentration of real paid usage in the entire country. It's not, it's not definitive how this impacts things, but I think it is presumptive. And so it's interesting to me that people were like not as interested in that, and that is totally fine. But I just, it's one that I would highlight as something that I think it will come up in the legislative session. So I would be interested whether the commission has a position to recommend to the board at this point in time, I guess is what I'm saying.
Kristen.
I'd like to go back to item number 2, the grant authority. I've been on the commission, I think I'm on my 3rd term, or I'm not sure. And I've said it all along. internally and sometimes externally, there's no teeth. We have no teeth here. And so we can try to help all of the people who come in. But when you don't have teeth, it doesn't really work. If there was one thing that we could do, and I don't know how, is that when we have tenants who bring issues to us and we listen to it, and we as a commission determine that it is warrant the next step, I think we should be able to require a representative of the offending landlord, property management company, somebody to come before us. And we can't do that.
Yeah.
We can hardly ask. There was a lot of conversation a couple of years ago about trying to set up us to be mediators. We actually had conversations with the city of Alexandria because they tried it and it failed. Because you couldn't require them to come. And I'm not suggesting that we become mediators, but it really hurts when you're in front of your peers and you have to account for the fact that you haven't returned 7 emails and you didn't take a phone call. It stings pretty bad. And unless you're
a public forum where people can report on you.
Right.
Yeah.
So if you're looking for a suggestion, that might be one. But obviously we would have to, as a commission, agree, because sometimes just our expert knowledge of years of doing this, having all the resources, we can tell them what to do, but sometimes it is so egregious. I'd like to just sit here, and I'm a landlord, and just say, come on, what are you thinking?
Yeah.
That would be a suggestion I had there.
And I guess that's related to number 3.
3 all go.
Because as we've seen it, I guess everyone we've received since last July has been some sort of retaliation, and the landlord not taking alleged action to rectify the situation. And like, we even heard it tonight.
I was thinking the same thing.
Where one seemed very logical to, part ways, and the other one, it needs more investigation into it since it's very complex. But definitely that first one, it's like, if you have a heart, it's a child.
Yeah. However, there, again, on this particular situation, as a landlord, that's really hard, because now I leave for marijuana. What about incense? And then what about heavy cooking smells? And everybody, people want you to stop shampooing the hallway carpets with your stuff because I don't like that. Or how about the things that, like the Westin Hotel has a smell, the W has a smell. So Ditmar wants to have a smell. Well, I don't like it. You're 1 out of 1,100 residents. So there are some.
Every
There are some
situation's
things,
unique.
right? But I wish we had some teeth.
And didn't the city of Alexandria have something that we were reviewing in terms of our authority that they had?
Yes, it's before the county board now, and the county attorney is drafting a policy for us to comment on.
Yeah, I'm just curious how that kind of coincides with the fact that, this would imply to me that localities don't have really any authority to enforce. So I'm just intrigued as to how.
Well, Virginia is a Dillon rule state, so unless the Richmond has devolved the power and authority onto the county, we can't.
I'm just intrigued as to how it works for the city of Alexandria.
I think theirs is a opt-in, mutually agreed upon mediation situation where if a landlord wanted to walk away from it, they can.
Yeah.
And I think the idea is kind of, as Sarah said, bringing people to a public forum such that the pressure is you participate.
Yeah. Got it.
But back to Kristen's point, there's no teeth behind it. There's no. Yeah. It's all just please be good. We really want you to be here. And that sometimes is effective. And
I would never show up.
if I were a shitty landlord, I'd never come here. What do you do?
But I will say for our landlords, though, they do show up, and I do applaud them.
For sure.
Oh, yeah.
For sure.
There's no incentive for anyone
Yeah.
to come before us.
Yeah.
Well, and there's no incentive, frankly, sometimes even for them to respond to us. You know,
Yeah.
I've definitely been in situations where we just ask tenants to CC me as a county board member on emails solely for like the force of name, right? Like I'm just being like, we are including a government official here. And even that is not always enough to like shift the dynamic. So having the ability, you know, even if it's a la code enforcement with like some kind of investigation fine situation, whether it's requiring, you know, subpoena is way too serious of a word, but like requiring presence in that kind of a way that if like a dispute has been made, a representative must be made available, like anything would give us, I think, something better than the status quo at this point.
I think 75% of the landlords would solve the problem so they didn't have to come here,
Yes.
Oh, yeah.
Yeah.
right? Yeah, because, you know, they have a month.
Yeah.
Yeah.
We got it solved. We don't have to
You don't have
show
to
up.
show up. Yeah. And ultimately, in most instances, that's really what we want.
Yeah, exactly.
That is, I think that's exactly right. Like, there's no interest, at least from anyone on the board, in like going after people. It's just people deserve like safe, healthy places to live. And which I guess I'm intrigued by number 4 here. I don't know who made that suggestion, but it's a drastic but interesting idea.
That came from Housing Commission's recommendations from last cycle. But I think we only sent 2 and 3 last time. Yeah, any other thoughts on our priorities? I mean, I could draft a letter that we could send to the county board, but I do agree, including number 9. Because AIs, especially at work, we had like a congressional hearing this past week and then one upcoming that is all related to AI in these mental health digital therapeutic space.
I think number 8 too is something that speaks a lot to what we do, and a lot of the issues that come up in front of us too. Half the time we're referring them to legal aid, counsel, and contact anyway. So having that kind of proactive step of trying to require that in leases, just so that contact information is already there. They don't have to come to us to get that information. Feels like something that's very kind of close to what we see a lot of.
And then doesn't it go back to, I know David's long program was to have that the Gold Star program.
It's very similar.
And they would provide that. And I know the county has always stated that we can't mandate that landlords provide certain pieces of paper.
Yeah.
Other than like the lease and other things. But yeah, I mean, it's common sense. I feel like just hear your rights. If you exercise them, that's on you, but at least you were notified.
Would that be a requirement on, I guess, the clerk of the court and how the piece of paper is written, or is that a requirement on the landlord when they communicate to the tenant? Because there's the official legal notice that gets served versus like the probably email or letter you received from your landlord. And I think it would actually be easier to put it on the official legal.
I would not want to leave it to the landlord.
Right.
Yeah.
That's what I'm getting.
They might.
I think the problem is, by then you may be too late to help
That's
the
true.
tenant.
Yeah.
The tenant needs to, in my opinion, the tenant needs to know multiple times before it ever gets there, because first off, they don't read it the first time. They're in denial. They're gonna solve the problem. Then they get the notice. They would need it multiple times.
Yeah.
And I don't think it's an impossibility to mandate that it's in there. I mean, they just mandated we list every possible fee that there could ever be at your apartment. I mean, that has to be on the front page now. Then we put the tenants and rights and responsibilities. They mandated that. So why not mandate a 1-page document? I mean, it's it's all electronic now. It doesn't,
Yeah,
it's,
so
yeah.
whatever you're.
Right. You know,
There was a
and you do it
Yep.
when you give your late notice, mandate it be on the back of your late notice. Because we all
That's actually.
do it,
That's a good idea.
electronically and I don't,
Yeah, no,
and we hand deliver it. And then when you give your 5-day notice, you do it again.
At every touch point, essentially.
Yeah, I mean, why not?
Yeah.
Because you just don't know when they're gonna read it and when they're going to realize, oh crap,
I
this,
really.
this could be me,
Yeah.
right? I mean, when you're late, I'm gonna catch up, it's gonna be okay, you know, I'm gonna borrow some money from my buddies or, you know, whatever. Then it doesn't happen, and, oh, I'm gonna get my job. Oh, I didn't get my job. Oh, I'm sure I hear the county's got plenty of money. I'm sure they'll give me emergency funds. They don't get it.
and I think to that piece, I actually just went to the fall meeting, which happened 2 weeks ago or a week and a half ago. The county is running out of money. Like we went from like knowing, oh yeah, this tenant, at least on our property, so you know they're working with the county. It might take a month, it may take 3 months, or it might take 2 days before that court date, but we're gonna get that money. Now they lowered the amount to only $2,000 per year per case. So it's one of those situations where it'd be good to put all of that in those papers. And now it's more important because if you have a tenant that's late 1 month, by the second month, you're gonna reach $2,000. And if they can't pay that, the county's not gonna help. And like she said, now everything's electronically, like as long as the property management or owners are using some type of property management software, it's as easy as just replacing that document, and thank God for merge fields, right? So it's super easy.
Is there anything in our second choice, which is number 1?
Didn't do anything for me.
Okay. Yeah. I feel like we've done a lot. I don't like how much more negotiating authority do you want?
Well, the reality is it gets to the point, right, where you're almost negotiating against yourself, because within all of the different community benefits that we're trying to get, you know, most of that, if it's a bonus density situation, which usually is where we're talking about most of these requirements, they have to earn up to a certain value dollar amount of the density that they're achieving. Well, you add more complicated and more required things, it eats up at some of that. And so you know, I don't know that it's a bad thing. It's certainly, we need more accessible design units, like that is known across the board. But you know, then it is also competing with affordability, transportation investments, you know, stormwater investments, other things that climate related investments as well, like other things that we use as negotiating community benefits. And so it's not necessarily good or bad. I think it's just a question of where people put their you know, desired nexus of specific things. And the hard part is, you know, I think everyone's a little disappointed in every community benefits package that we have, because it doesn't have their preferred mix of all of the things, but we try and as a whole reach an okay place. So
This seems like by consensus, it seems 2, 3, 8, 9.
We put 2, 3, that's 4.
Yeah.
Oh, I thought we were only doing 3.
Yeah.
I mean,
3, it doesn't matter.
4 won't hurt.
Okay.
I feel like our neighboring, our sister commission has other.
No, they didn't vote on all of it.
Oh, they haven't voted
They
yet.
haven't voted yet. Yeah,
Okay.
so they narrowed it down from 23
Okay.
down to however many percent on the original
Okay.
thing. That's what they
Okay.
voted on, and then they narrowed it down.
I think our
There
4.
were 29 on there.
Oh, then
Don't consider it.
there was, yeah.
Legislative package, actually.
Yeah.
If there was 29, then they got it down to, I think, 10 or 9. And then whichever ones that we had that came up, I just highlighted those ones.
Okay.
I mean, I don't know what they're gonna pick though.
Okay, so,
So if 9's making the list,
yes.
Guys can.
I'd like to change the word from stop to investigate
Mhm.
or something, because stop is so big and I'm a landlord.
Mhm.
We don't do that. And I've got 5,000 units in the county. And I don't know that, but the market tells us what to pay, what we can charge. I mean, if I charge, I mean, I have a problem with the word stop. But I don't mind. I think AI is taking over the world. I think that there are a lot of concerns that we should all have about it. And I do think that there is a potential for bad to come from it. But that's too big of a word.
Mhm.
Just something a little softer.
Okay.
I don't know.
No, I agree because I mean, on our end too, like we don't use that, and nowadays, anybody that comes to us asking, hey, you know, this is a cool new feature, do you have this? And the first question that we say always, me and Gerald, is, so how are those lawsuits going?
Yeah.
I think it's such a it's such a
Legal fees are you?
and they're always like, well, you know, it's still a thing, you know.
Yeah. Okay.
I wonder if this may be an artful language, and I wonder if it's really the gist of what I think what I would want to see is really more around strengthening antitrust provisions in like rental housing markets. Like, I think that's really what this is trying to get at, because the AI, while it is a problem, in this situation, it's less the use of AI and it's more the like
price fixing part of it.
conspiratory,
Mhm.
yeah,
Right.
sharing data that never previously, and it's AI is enabling the ability to draw in and pool all of these sources that had never been able to be combined by a normal human before.
I will even, sorry,
Yeah.
I will even add, instead of the whole idea of like stop the use of AI for price fixing, kind of like even now with like the new generation with social media and everything, it's like now they're required to put in every post or anything, this is an ad or this is created by AI.
Disclosure.
Or a disclosure from the properties. Hey, we often use AI for X, Y, and Z as a disclosure at the end, and then call it a day. Because at the end of the day, we also cannot disclose some of the private information or how we do certain things, but for the public to know that there are some AI usage.
And maybe tying back to the VRLTA, that there's updating the privacy section to incorporate that. Maybe we can lobby that the information does not, your private information, your PII is not incorporated to AI.
Yeah.
It's shielded from, keep it on a different server, et cetera. You could run all the algorithms you want, but it can't be with this data.
Or, you know, it can come down to, like you said, privacy. You cannot use data to start doing email threads with your tenants because there might be secure information on PDFs that shouldn't be out there if you ever get hacked, right? Because I know now with Gemini and a lot of companies use, I'm against it. One of the things, even with the firewalls, using Gemini as an email thread for your tenants is, I mean, this is all brand new stuff. I mean, we don't know if this ever gonna get hacked. And then that's not part of, and, you know, and if you really think about it, Gmail is not covered under the liability of our insurance using a property management company. Like if Yardi gets hacked, you know, yeah, we need to put the letter and do X, Y, and Z, but they're the ones paying, you know. With Gmail, I mean, even Gemini, I'm really against that.
That's really interesting, though. I never thought about the liability aspect on like the flip side of that.
Yeah, like, you know, anything on our servers from our at least the company that we use is part of a master contract. If something happens, this set of provisions that come with that, God forbid this happen. But I mean, you know, what about Gmail? Yeah.
Well, thank you. I'll try to draft and summarize these comments with Kara, and then we'll send you a draft memo that before we send it off to the county.
Thanks.
Moving on, I just, an announcement for the November meeting will be virtual and the December meeting will be canceled as we normally do, unless there's an emergency and we need a summit meeting. The November meeting will be virtual, the December meeting will be canceled. If you're all in agreement, and we'll only convene on an emergency basis if need be turned off. Okay. Turn over to Kara. I know we received this letter from the NAACP. I don't know if you all had a chance to read it. Yeah. They made some accusations that the ordinance has not been updated adequately and it's not in compliance with Commonwealth law. Even though I did look at the ordinance today and it said it was updated, I mean, I'm not a lawyer either, but it said it was updated in 2024. I don't know if the county has any updates regarding the letter. I know we only just received it.
Yeah, I just received it Tuesday, maybe.
Okay.
And I, of course, added it into the letter that we had for Green Valley. So I haven't heard anything else back from anyone regarding it.
Okay.
I will say, I believe the Human Rights Commission is already
Okay.
looking into a lot of this, so I think those who are interested should definitely coordinate with the Human Rights Commission, and I know the Housing Commission has also been very interested and engaged, so.
And I know the human rights ordinance is within our purview and charge per the charter. So because of the tenant retaliation segments of the ordinance. I guess, Kara, if we can coordinate and get updates from the not Housing Commission, the Human Rights Commission. And see where we can fit in, if they need a representative from us, or if we could just get a briefing. And then I guess we'll coordinate to see if we need something for the October meeting from the Office of Human Rights.
You want me to reach out to Housing Commission as well?
Sure.
Yeah.
Make sure, might as well do it all at once, so we're all on the same page rather than play telephone. Okay. And then the last item was the draft letter for Green Valley. Kara and I were quite busy from July, after the July meeting. So we did meet with the residents of the Shelton at the end of July. We also met with Green Valley's leadership. And we followed up with ACPD, and where the tenants have also been chatting with us offline as well. So here's the draft letter, and we did meet with AHC as well about a week ago now. To conclude, and we sent them like 18 questions, and they answered them all. And we also, on a separate note, also met with the Gates of Ballston, and AHC is also the landlord of that property, and we met with them regarding that. The concerns there. So, but in front of you is just the draft letter. I know I need to tighten up like some of the words in the top line. It's just, I was like too many fours. But if you're all okay with it, or if there's any edits, please let me know. If not, I'll ask, I don't know, Kara, if you prefer to send it to Green Valley, or if it's okay if I send it.
You can send it to Green.
Okay, and I'll CC you. But yeah, it summarizes basically their assurances. A lot of the concerns that were raised in the residents meeting were around personal safety as well as building safety. And it also focused on upkeep and wanting a public space to commune. So that there's issues regarding the usage of the community room space. So now they're setting up a reservation system of some kind so they can rent the reservation room free of charge, I believe, but just so that there's a priority list. And they're looking at ways to reimagine their central courtyard, because right now it's just landscaping with retaining walls, and there's no real, it's not a courtyard in like a plaza. It's just a walkway with some space in front of the community room, but that's about it. but it's not really conducive to residents convening, and maybe that might mitigate the issues that we've heard, that they're convening outside of the egresses in front of the building. And then I know the county is working on building some shelter or some type of shade across in the main square. I think it's John Robinson Square. Yes. But is there any questions you have for Karen and I regarding?
I think that probably the most disappointing thing is for the residents, it will be 6 months to a year before they see any change at all, period. I mean, with the transition into the new management, it's gonna be a slow go and that's just, it's a disappointment. And you were very nice about how you said it. It's gonna take time, but it's gonna take a long time.
And we've learned from Crystal House as well that the transitions are not easy.
No, no, for sure. And then, you know, the new management company, they're coming in with their own agenda. They have their own priorities.
I will say, the county board and senior county staff are very engaged in this topic, both the Shelton and the property management changeover at large. We county board members have met with AHC leadership over the past few months, and senior staff are managing that relationship. But this is, you know, it's gonna take time, but we are also not just kind of letting it run and see what happens. Like, there's gonna be a finger on the pulse, and I'm very appreciative to housing staff who I know have been
Yes.
very busy this summer. Who probably heard more from me and my colleagues than they've ever wanted to. But I do think we've reached a pretty collaborative relationship at this moment. And I feel like AHC leadership has heard what we need, what people are saying. And so, for the time being, I think we're hopeful that this continues to progress, and then we're really awaiting that management changeover, because it is going to, all change is hard, and it's just about managing the impacts and trying to get to a stable place as quickly as possible. But I know that is definitely an anxiety that everyone is feeling. And so we don't want it to feel like you're like off.
Yeah.
No one's paying attention to
Yeah.
you. Like, we're with you. We know that this is going to be a lot.
And
Have they talked to you about the new management company and their staffing situation? Because that has always been a huge problem, is that
Just the numbers.
the number of staff that are dedicated to the properties and dedicated to it. And I think with this big of a transition, it's going to be huge. Was there any discussion at all? Like, are they keeping people, not keeping people? Are they bringing extra people in to smooth over the transition? And I'm just curious, probably more than anything.
Yeah, there was very little talk about, that. I know that they are trying to retain as many employees as they can. I do believe that the manager, that's at some of the properties they are going to keep, but I have heard that other staff have already looked for other positions. And of course, as with any change, people left. But I think this Shelton might be one where the manager's going to stay. Like, that staff might stay. So
I think there was also a suggestion from board of, can you have AHC people on site to, maybe not get involved with the property management, but like just be there so that you can see what's happening. And if something is amiss, you're already there. Like, people don't have to come find you. So I know that was one of the suggestions that was made.
Yeah, one of the things, like what she said earlier about the ranks for the other topics that we picked, the whole idea of not having teeth, right? I think in this type of cases of at least transitioning, she brought a good point. I mean, it will take time, but also it comes down to staffing, right? Have the commission ever thought about, like, in those type of situations, ask or give recommendations of like, if they tell us, hey, it's this amount of apartments, you know, the garden styles, it has this much buildings or this mid-rise, whatever the case is. And for us to come up with like our recommendation of the amount of staff that we think that property should have, at least for the first 6 months of transition, to like deal with X, Y, and Z.
I don't know if, and that would be interesting. I don't know if your field, there's a recommendation. I know when we were speaking at the Gates of Boston, they said they were down they were down 3 additional maintenance staff. They were only 2. They just hired a maintenance manager. So they're up to 3. So technically they're still short 50% of what. So I don't know what formula they use to say that they need 6. I don't know if it's the number of units. We could definitely look into that.
I mean, I think there's not a magic formula. I think it's just like, I guess, knowledge of like the amounts of
The recommended, yeah.
yeah, like if this property has 6, 7 boiler rooms, X, Y, Z, all of that plays in effect to that, right? So,
Like what's recommended, like the industry standard. If you have 1,000 units, then you should have 5 maintenance staff or et cetera. Something along those lines.
With all the drama associated with it, it seems to me that in our world, we call it a lease up. You treat it like a lease up.
yeah.
You treat it like you're starting fresh and you need 1.5 times the staff that you normally have during a lease up, because everything just takes more time. The management is going to be sitting with all those complaining residents, and it's not a 5-minute conversation. It's a 25 to 30-minute conversation. And then there's going to be follow up. And it's just like when you do a lease up, normally if someone comes into one of my buildings, I have 2 options for you for a 1-bedroom for October 1st. So I can only show you 2. That's all you get, right? But in this situation, they're just going to have so many things happening. But again, I think it's a great conversation point for county and for staff is to suggest to them that they have extra people, because everybody's going to want to talk to them, and it's not going to be fast.
And to Adrian's point, Saul was present with me at the Gates of Boston. They do have on-site staff from AHC in their resident services department, but there's still, from what I saw, was some disconnect between what their role was. I don't know if it's supposed to be eyes and ears or just provide resident services and not really mitigating to the day-to-day operation. I mean, that's a follow-up question we could pose to AHC, but so I don't know if there's anything.
Well, we go back to the having teeth or no teeth. So while they may have resident services at their properties, it's the authority that person would have that would be, given by AHC and say, hey, so you have to represent residents, you should be able to intervene and help resolve. But it doesn't seem that is happening. And so what they're proposing is having someone from AHC Inc., other than resident services, being at the properties. I think that's a good idea to have someone, like, for example, I talk about having asset managers that oversee the properties. So if they're having on site, I think in AHC, providing that person with authority to say, hey, you are here representing AHC Inc., and you are hired as the management company to operate and serve the residents. And so we delegate some of this authority to you to oversee the properties. So that's where I see it working.
Yeah,
so that has to happen.
Yeah, and we're not talking about this. It's like a thing that they have to do for like the long run. It's just a short period of time to get their, the wheels going. In the company, for the company I work for, I've done 4 transitions. I've taken over 4 different properties once the property managers have retired. And I can tell you that the first month, I'm barely on the office because people come in and it's like, oh yeah, you're the new Nick, or you're the new so-and-so. And a lot of the times my standpoint is like, yes, you can give me a complaint, but I gotta show the empathy that put myself in their shoes. So I'm the type of property manager. Okay, you know what? Let's go. I'm a visual person. Show me. Let's go to your unit. Let me take some pictures. Let me see what I can do. And that's another way also to handle that. Like I remember when we were, I think 2 months ago with Crystal House, with the whole ticket situation.
Yes.
What I've done again, kind of taking over, working with the company, I've actually gone and literally closed every single work order, but with a comment that says, hey, new management, this might be open, this might be done, but if it hasn't, put it back or give us a call, right? Because like that, not only you get that one-on-one maybe with the tenants, but yeah, you need more staff.
Yeah.
You
And
know,
the Crystal House situation was unique because the previous property management seemed to be literally cancel contracts. Like,
Oh, yeah,
close them
yeah,
down and
yeah.
go home.
that was.
Well, and even then, like they even mentioned their first 30 days, they had double the staff on site than their like full-time plan. Like they were trying to bring in a bunch more people to help with that initial transition. To your point, I think they were not
Yeah, it was
an
a lot.
easy hand with
Yeah,
the
that one was a
property
lot.
manager either, but.
So, there was one last item. Thank you all for that productive conversation. We're doing it in a handful of time. I'll just draft the letter also. It's just gonna be an endorsement of the report that we hear from Jennifer. I don't know if you all want to see it, but I'll just send that along then to the county board. Yeah. That's all we had. I don't know if Kara or Hector, do you have anything else?
No.
Okay. Well, thank you all. Is there a motion? There's a motion to adjourn.
Second.
Has been moved and seconded. All those in favor?
Aye.
All those opposed? Meeting's adjourned. Thank you all and see you next month. Whew.
See?